I'm former California Superior Court presiding Judge Cheryl Ellsworth, and I've been on the front lines of resolving parents' conflict for decades. But as a twice married, once divorced mother of 6, I've seen it all. Whether you're dealing with a true parenting partner or a genuine jerk, there's two sides to every story. I want to hear yours. This is the coParenter Project, and I'm here to answer your co-parenting questions. Hi guys, welcome to the coParenter Project. We've been seeing today's question become a lot more common in recent years. My ex is taking me to court because she wants full custody of our children. I have no idea what to do or what half of the terms on the forms even mean. There's no way I can afford a lawyer. What are my options? This is the judge talking, and I can't give you legal advice, and certainly I would encourage you, if you can't understand the information that you're receiving, to get legal counsel. But you can take a little bit of a breath here, take a beat and understand that unless you've done something in your life or you're continuing to do something that's adverse to the best interests of the children, not likely that you're going to lose your custodial rights. Not likely that you're not going to have some parenting time with your children, and it's not likely that you're going to lose out. There may be lots of reasons for your frustration. Perhaps you can't afford an attorney. Perhaps you can't understand the paperwork you've received because English isn't your first language. Maybe this is all new to you and you've never been a part of the court system. Well, the good news is, as a judge, as a court, we want you to understand everything. We want to make sure before you give away a right or lose a right or have something occur in court that affects your rights or your family, that you understand what the proceedings are. Most courts have a Family Law Assistance Center. You can access this Family Law Assistance Center in order to receive help in understanding your forms and also for filling out your forms so that you're better equipped. I can't tell you whether to get an attorney or not. That's not my call. But I can tell you, at the end of the day, understanding is access. And courts are all about access and fairness. That's what justice is all about. Your question is scary. That's overwhelming. I mean, to be threatened with things and words that you don't even understand is something that gives all of us pause. I want you to step back a little bit though, and let's talk about this like I'm your neighbor. I'm a child advocate, I'm a parent, I'm somebody you know. Let me tell you a dirty little secret they don't tell you. But about 75% of all cases in the state of California at least has one side that is self-represented. Even though it's not fun to go to court, and even though it's based on an adversarial or that each side goes in and does war essentially, it also is very well adapted in family law to embrace the notion that one of you may be representing yourself. Don't give up. Get in there and get the information and make sure you understand what those terms mean. There is help out there, and your child deserves for you not to give up. When you represent yourself, you may be called a couple of things. You may be called a pro per litigant, or a pro se litigant, or a self-represented litigant. All of those things mean the same thing. It means you are going to act like your own attorney. In the court system, you have the right to do that. Many, many people represent themselves. Maybe you can go outside of the court system, a mediator, or a helper, or an individual who's what we call a neutral, who's not a court member or even a court staff. They can help you try to work these problems out. Many of those individuals speak more than one language or have the ability to make sure you hear things in your native language. It's important for your child that you understand these forms and that you act on these forms.